All right, everybody. Welcome to the tax section's program on employment tax obligations, trust fund recovery penalty, and employment tax criminal enforcement. Before we get started, I just have a couple of housekeeping details. An announcement: you will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. This program will be available in a couple of days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Program. The tax section is sponsored by Hochman, Salkin, Tasher, Perez. We want to thank them for their perennial sponsorship of the section. The Hochman, Salkin, Tasher, Perez PC Advantage is experience, an eye for innovation, and a genuine dedication to clients, their families, and their business. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state courts, the firm is also active and successful in handling non-tax matters such as business and estate planning for high net worth individuals and closely held businesses, together with white-collar defense and commercial disputes. And now we will go on to our program. I'm actually going to be presenting today together with my colleague, Gary Slavett. Gary and I both are former IRS counsel attorneys. We handle tax litigation, criminal tax defense, tax audit representation, administrative appeals, sensitive voluntary disclosure matters. We represent clients before the United States Tax Court, U.S. District Court, IRS, U.S. Attorney's Office, Franchise Tax Board, State Board of Equalization, and Employment Development Department. And as I said, we're both former IRS counsel attorneys, and we welcome you to this program. So, Gary, why don't you get started? I'm going to share my screen. Again, I just need to do this. No. Give me one moment there we go. Okay. All right, can everyone see my screen?
Yeah, it looks great.
Okay. All right. So Gary, why don't you get us started? And
Sure. Good afternoon, everybody, and thank you for joining the webinar and spending the next hour or so with us on the exciting topic of employment taxes. Right? Woohoo! You know, why are we here? Most of us think that employment taxes is kind of something that's been pretty static for quite a while. I believe Congress passed the current kind of employment tax withholding regime back in the 1940s. So we're what, 80 years into withholding taxes and putting the burden on the employer to withhold basically what I always consider doing the government's job and not getting paid for it. But that's so be it, and that's the obligation of the employer. With that comes obviously, you know, employers have to hire payroll companies and the such, and it comes with obligations that they must collect and pay over. So why are we here? Well, unpaid employment taxes, I think last I saw, we're at about $60 billion. And that's unpaid employment taxes. That's the amount that employers reported on their 941s and just didn't pay. So there's substantially more for people that aren't doing it correctly, meaning maybe misclassification, not filing returns, but just with returns filed and non-payment, $60 billion. And so the IRS, you know, many years ago, somewhat recently said, well, wait a minute, this is a big problem. And civil and criminal tax enforcement is now among the IRS's and the Department of Justice Tax Division's highest priority. The IRS commissioner announced that that's going to be their priority. There's a special enforcement kind of campaign going on. And what we used to see as just civil enforcement has turned to criminal investigations and criminal enforcement. And that's kind of what we've been seeing in the last 5, 6, 7 years that has changed. This has turned into something much more scary for our clients and for all employers out there. And so the one takeaway, well, this is kind of, you'll see throughout the talk, the webinar today, is have your clients pay their employment taxes. That's, you know, very important, especially the trust fund tax. And so that's why we're here. We're seeing a lot of activity on this, and Michele will go into the civil trust fund aspects. Well, I guess you'll explain the agenda, right, Michele?
Yes. All right. So I'm just going to put the agenda up on the screen for a brief moment. Okay, so this is what we plan to talk about today. We're going to start off talking about the civil liability, which is the federal trust fund recovery penalty, criminal liability and enforcement. What we're seeing now also are IRS civil injunctions. We'll talk briefly about the employee retention credit. It's enforcement. It's not 100% related, but it is about, it does deal with employment tax to some degree. We'll talk about California employment tax issues, and if we have time, we'll talk about the IRS Voluntary Classification Settlement Program. So with that, I'm going to advance to the, here we go. Okay, so for civil liability, there's something called the trust fund recovery penalty, which is pursuant to IRC section 6672. So let's just get into it right now. So as an employer, you have the obligation to withhold and pay over your employee's share of income tax and also the employee's share of employment tax. And so that is what this statute requires you to do. And if you don't, you have personal liability for not paying this over. And we're going to get into who is a responsible person and what willfulness is all about and so on. So if you look at it, it's a pretty strict liability type of statute. It's that the employer had the responsibility to collect and pay over employee withholding taxes and failed to do so. And it creates personal liability for the trust fund portion, which is the amount of the withholding. So just to clarify, on the federal side, it does not include the employer's share. Not necessarily on the California side, but on the federal side, it is only the withholding portion that creates this liability. And it applies to a responsible person who willfully fails to collect or pay employee withholding. And a common situation that we see, it arises with a company that's in financial distress, and the company uses the funds, business funds, to pay creditors rather than employee withholding. So one of the things that people ask about is, why is there personal liability? And to just paint you a picture, when an employer withholds money from their employee's paycheck and they are supposed to pay it over to the US Treasury or the California Treasury, the government views that employer basically as standing in a fiduciary relationship to the taxing authority, to the governmental agency. And so if you fail to pay it, so when you've collected it, you are now the fiduciary for the government and you have an obligation to pay that over. When you fail to do that, you have failed in your fiduciary responsibility. And that's sort of just as a policy matter, what's going on here. So the things to look at in this situation is, who is it? One is, who is a responsible person? And the other is, what does it mean to be willful? So I have the next slide. So it's the person who has the duty to perform and the power to direct the collecting, accounting, and paying trust fund taxes. And then I have a list of different types of people. Courts look to different factors: their position in the corporation, their authority to sign checks, their control over financial affairs. And you can read the list. It's somebody who really has the responsibility for paying over. So for example, it's not the person sitting in the cubicle who might physically process the checks. It's the CFO or the CEO or the person who actually makes the decisions for the company and where those funds are directed. And there's also another statute that comes into play, which is called the government priority statute. And under that statute, basically the government always gets paid first. So this person who's responsible, and I'll show you some case law about it, the person who's responsible needs to pay it over. And anyway, let's get into this case which I thought really helps you understand who this person is. So again, it's an officer, corporate director, a shareholder, board member of a nonprofit, or any other person with authority and control over businesses' disbursement of funds. Another thing I want to mention also about the this trust fund recovery penalty or the responsibility for the withholding is that it's unlike income taxes, it is not dischargeable in bankruptcy. So once you are tagged with this trust fund penalty, it follows you around until, of course, there's a 10-year collection statute, but it's always with you and you have to deal with it. It's now your personal responsibility unless somehow the company pays it. The IRS doesn't expect to get paid from both, but they expect to get paid from somebody. So I looked at this one case, Dixon v. Commissioner, and I thought it was a really good illustration of what it means to be a responsible person. So there are different years at issue, and for some of the years, so there was a son and parents. The parents were indicted on tax crimes, and for the years that they were indicted, the court found that the son was really acting at the directive of his parents. He wasn't really the responsible person. He discussed everything with his parents regarding employment taxes. His parents said they would handle it, and the son worked much more on the operations side. However, in later years, he had signatory authority over the company's bank account. He became the president and sole director. His parents had been preparing him to take over, and so he ended up being tagged with the responsibility for those later years. And we see this a lot in our practice. Usually the typical example that we see is a situation where the company is in financial distress and the owner or the CFO or whoever it is will just be trying to keep their company alive. And so instead of paying over employment tax, they're paying rent, they're paying the net check to their employees, they're paying vendors, they're paying for electricity and phones and that kind of thing. Well, it doesn't really matter if that's what the problem is. You still have that personal responsibility. So now we know who a responsible person is. It's the decision maker. Now the other question is, what is willfulness for the purpose of this statute? So, it requires a voluntary act, but in this situation, the willfulness is really just that the person who is responsible knew that the taxes were due and didn't pay them over. It doesn't matter what the circumstances are. They had to know about it. So going back to that case that I discussed with you, well, the son knew about it. He wasn't the responsible person, but I have some cases coming up, but just thinking about it, it's not that you are willful in sort of like what you would think of a bad kind of willful way or a negligent willful way. The intent is just because you knew the taxes were due and you didn't pay over, that's it. You get charged with personal liability. And I saw actually in our practice when there's a lot of, like, for example, there were many cases in the 2008-2009 period, when people were in financial distress, and continually to this day, the typical scenario is a financially distressed company. It's not that the person was trying to be avoidant, it's that they just really were in a bad position. So I have some cases that show examples of willfulness. So here's one which was frustrating, but you can look at the first one, in Ray Gregory Rutherford, that the responsible person, knowing about a company's financial distress, should alert a responsible person of the risk that withheld taxes are not being remitted. They can't immunize themselves by wearing blinders. So, you can't say, I didn't know. If you had the responsibility, you knew about it, you didn't pay it over. And you can't say, well, I didn't know. If your company is in financial distress, that should be a signal to you that you should be paying attention to what's going on with your payroll taxes. Then there's other situations where a person failed to investigate or correct mismanagement after being notified of a default in payment. They should have known. They can't just not know by just ignoring things. Ignoring things. So, then there's another one, Frank I don't know how to pronounce it, but where the court found no willfulness by the president and 50% shareholder of a failed corporation who did not know of the corporation's employment tax failures until after the company had failed. And somehow, and this company did not have a history of tax delinquency. Somehow the court was sympathetic. Are there huge distinctions in the facts? Not really, but in this case, the taxpayer was able to prevail. And the unfortunate case in Robert Landau was the person had an addiction problem, and the court found that it doesn't absolve willfulness. So those are just the things that you need to think about when it comes to the trust fund recovery penalty and civil liability. And this is why we always tell clients, if you are in distress, the first thing you do is pay over your withholding. Usually that tends to be what people think they don't have to do. They'll pay rent, they'll do all these other things, and then they find themselves in a bind. And so, Gary, I don't know if there were some other points you wanted to add about this, the civil side of it.
Sure, talk a little bit about a couple points, kind of practice tips. Well, what we see is when a revenue officer is assigned to the case and is looking at who is potentially responsible person, the first thing they generally look at is who's a signer on a bank account. And so one thing that individuals can do to protect themselves is if they don't need to be a signer, don't be a signer. And so generally the owner is going to have to be a signer, the CEO may have to be a signer, but does the controller, does the CFO, does the treasurer, the more people that are added as a signatory on the bank accounts, the more the revenue officer will look at every person who's a signer as a potential responsible person. And hopefully they come to the conclusion that if it's a controller who's really taking direction from the CEO, that they really aren't responsible, but we have to fight those often. So the best thing to do is, if practical, do not be a signer on the account. Because what happens is if the IRS determines, the revenue officer determines that an individual is responsible and they believe they meet the willfulness, they will issue what we call a 60-day letter. And the 60-day letter allows the potential responsible person to go to IRS appeals, okay, or the Independent Office of Appeals. And for all practical purposes, that's the last stop. Why? Because after the IRS appeals, you can't go to tax court. You got to pay some of this and go to district court. And we all know, if we don't know, district court is very expensive, much more expensive to litigate in than tax court. So there, we've been pushing, the tax practitioner community has been pushing for a long time. And in my opinion, TFRP determination should also have tax court jurisdiction, because with many of our clients, in practicality, they don't get their due process rights. The government will counter with that, say you can go to district court, but for many of our clients, it's not affordable. So you want to really try to nip this in the bud at the revenue officer level, because it's also very difficult to win this at appeals oftentimes, unless the success often comes is when the revenue officer makes somebody responsible who really is lower down on the chain that just may happen to have signing authority. And so those are the important parts of this. And then what Michele said is we advise clients, and everybody should be advising their clients, if they can't pay the whole part of the employment taxes on the 941, at least pay the trust fund portion, right? Which is the employer's share of Social Security, 6.2%, employer's share of Medicare, 1.45%, plus the PIT or the personal income tax withholding. At least pay that. And so when clients come to us with liabilities, the first thing I ask them is, can we at least take care of that? Because by taking care of that, it also pretty much takes us out of criminal issues usually. And so, those are kind of the key takeaways.
Okay, so the next thing, speaking of criminal liability, we're going to move on to that. Let's see, there we go. Okay, so now we're going to look at criminal liability, and we're going to look at the statute, and you're going to find out that, well, let's just look at it. So here's the statute. Any person required under this title to collect, account for, and pay over any tax imposed by this title who willfully fails to collect or truthfully account for and pay over shall, in addition to other penalties, be guilty of a felony, and so on and so forth. And so when you read that, you'll say to yourself, gee, that doesn't sound a lot different than civil liability. And that's because it really doesn't. It's a relatively strict liability type of situation. It's just a matter of if you are the person who is responsible for collecting and paying over, and you don't, that's it, it's a crime. And so the difficulty is that if you fall under the trust fund recovery penalty, you most likely can also be charged with criminal liability. And just on that point, you know, when I give these presentations on employment tax often, and it used to be in prior years, you know, I would always find that when there was criminal liability, there was always something else going on, whether it was a discovery that the employer was using the funds for personal reasons, or they were paying some portion in cash or moving things around, or some other sort of, for better, you know, using technical term, finagling or machinations with regard to employment tax. But lately, we're seeing situations where it's just that the company was in financial distress, and that's why the employer failed to pay over. And in those situations, these individuals are still being charged with, criminally, and they have to go through the whole process. They're now dealing with the Criminal Investigation Division. They're dealing with the U.S. Attorney's Office. They only wish that all they were dealing with was a revenue officer and figuring out how much to pay, because they still have to pay, but now there's a potential threat of a prison sentence. There's a felony conviction on your record. Could really be a problem if you have certain, you know, depending if you work in a field where there's licensing or all the other terrible things that come along with a felony conviction. And what I did with the material, what we did, I should say, with the materials is at the back, I attached a lot of, the Department of Justice has press releases, and I attached a lot of releases about different people who are convicted of employment tax crimes. And when you go through them, you'll see that a lot of them involve people who were involved in potentially other nefarious acts, or maybe they paid what one employer paid their employees partially in cash, or another employer also had income tax issues, or there are other things going on. But some of them is just a straightforward, they were supposed to collect employment tax, and they didn't pay over. And also, when you read these press releases, or if you read the indictment, or, you know, it'll have the language in there that says that the particular taxpayer who's being criminally charged collected but failed to pay over. In most situations, they really haven't collected. They've paid their employees the net check. It's just sort of that, well, they collected, but they didn't pay over. And it's a difficult thing. It's a difficult thing for these companies in financial distress. And then sometimes if you read some of them, and I encourage you to read them, they're short, they're really interesting reading. You know, in some situations, then that's when people start doing silly things like moving things around so that the IRS doesn't, you know, totally figure out what was going on, and then they get into more problems. But at the core of it, all that really happened was they didn't pay their withholding portion. And just on another note, the employer's share, failing to pay that is not going to cause you to have criminal liability unless there's a lot more going on. But the 7202 is only with respect to withholding. To be charged with criminally with the other portion, there would have to be, it would be 7201. That's, you know, evading and avoiding and that kind. So it's almost a strict liability type of statute. It actually is, because again, it's finding the willfulness is, again, if you knew you had to pay it over and you didn't, you're now willful. It's not the willful when you try to think, it's not willful in a mental state type of way that you willfully didn't pay it. It's that you knew about it and you didn't pay it. So I don't know, Gary, I think you had some
Well,
points you wanted to add.
I think this is kind of the area that we've started to see change in with respect to criminal cases, and we're seeing that, you know, we talk about it amongst ourselves as a kind of a strict liability, almost crime, in that we normally think, we learn in law school, right, you need mens rea and these types of bad motives and evil motives and bad purpose, and really the statute is written in such a way that you don't need that. It's like Michele said, it's very similar to the TFRP civil statute, and really you just have to show that you voluntarily and intentionally pay net wages to an employee with the knowledge that withholding taxes were not being remitted. So you just have to know that there's an obligation to do this, and that's enough for the willfulness standard. The DOJ, you know, they successfully argued in 7202 cases that repeatedly paying net wages to employees, knowing that there are insufficient funds to pay the withholding taxes, constitutes the criminal willfulness in and of itself. And so this is kind of scary to us, surprising to us. Michele and I are currently now working on a criminal employment tax case, and we you know, had a meeting with the Department of Justice Tax Division lawyers and tried to make the argument, you know, we have a case that really there's not much else here. What we normally see, like Michele, what we used to see is a taxpayer lying to a revenue officer, a taxpayer living extremely large, huge houses, fancy cars, and just not paying, hiding money offshore. But now we're seeing, and we have them in our office, in our practice, now we're seeing employment tax cases without that, just simply pyramiding, meaning multiple years, but nothing, you know, even with acknowledgement from the Department of Justice that, yeah, they didn't, your client didn't have the money. We don't have any evidence that your client's living large. We don't have any evidence that your client lied to a revenue officer. And so in our talks with DOJ to try to get them to do a declination, you know, the response from the tax division lawyer was, we're doing this because we can. It was kind of disappointing. We can do it. Look at the elements, Gary. Look at the elements, Michele, of 7202. We can do this. And so what does that mean? They can do this in any case where the civil, I think, where the civil TFRP requirements are met, which there must be over 1 million of those out there. I mean, there's hundreds of thousands of employees continually not paying employment taxes. Any one of those can be criminal. Now, the IRS and the DOJ don't have the resources, and so there's still maybe an element of something else having to be occurring for the DOJ or the IRS to get wind of this, and perhaps it may be just some other civil litigation, maybe something else going on. But this is kind of you know, the scary part of employment taxes. And you know, there's a 6-year statute of limitations from the succeeding April 15th of each quarter, so essentially 6 years. And so there's plenty, that's assuming you file. There's plenty of time for them to go after people. You know, the IRS can do this on 2 fronts: an admin case or a grand jury case. And one of the things that if a client calls you and says, "Oh, the IRS knocked on my door with respect to my employment taxes," the first question a practitioner should ask is, "What do you have the card? Let me see the card. Let me see. Do you have the letter? Let me see the title, right, of the IRS employee. Is it a revenue officer? Is it a revenue agent? Is it a special agent?" And I always hope that it's a revenue officer or a revenue agent. But if it's a special agent, then you know where you are. And so the IRS can do 2 kinds of cases, right? Admin cases and grand jury cases. They both have their pros and cons. Most of the time, the grand jury cases cases get an AUSA assigned, and there's the IRS and the AUSA conduct themselves in secrecy. They're allowed to conduct themselves in secrecy. Oftentimes, the target finds out that they're under investigation during a grand jury case when the grand jury subpoena goes out to the bank or goes out to a third party that then informs the target. With respect to an admin case, that means the IRS it's within the IRS function, and they are controlling the case. They have less secrecy rights. I mean, they have to give third party notices, and they issue summonses. So also another a tip off when a client calls you and says, "Oh, one of my employees got a summons from the IRS." Well, is it a summons or is it a subpoena? If it's a subpoena, it's grand jury. If it's summons, it's admin. but summons could also be from the civil component of IRS. So those are kind of some things to look for. With respect to any tax crime case, the Department of Justice Tax Division in Washington, D.C. has the ultimate decision making whether to approve or decline. So they have to authorize all criminal tax prosecutions. And so that's a little bit different than other federal crimes where it's usually the local U.S. Attorney's Office. Here there's a dual role. There's the local U.S. Attorney's Office, but ultimate approval has to come from the tax division. And what that allows the practitioner to do is that you're entitled, or at least to request, a conference with the tax division attorney prior to the making the decision, whether to approve or decline. So what happens is the IRS makes a referral to the Department of Justice, and that referral is reviewed by the DOJ tax division, and try to get in there before they make a decision, and they'll grant a conference. Generally, you'll hopefully have an idea that it's being referred, and you ask for a conference, and you try to convince them not to approve the prosecution. It's very difficult. It happens. I've been successful to approve to get them to do a declination. What then happens is the IRS, they can take it back, and criminal can take it back and do more investigation. That generally doesn't happen. Once tax division DOJ declines, which doesn't happen often, but does happen sometimes, the IRS will send it back to the civil component, usually for civil fraud penalties or civil case, and that's a win if you can get that to happen. With respect to admin cases, you also can request a conference with the IRS CT criminal tax lawyers. There's a group of lawyers that work for the IRS Office of Chief Counsel that are designated as criminal tax lawyers, CT lawyers, and they advise the criminal agents. And in an admin case, that case has to also go through the CT attorneys, and you can request a conference with them to try to make your arguments. So you can get kind of two chances with the CT, one with the CT lawyer, one with the DOJ tax division lawyer, to try to convince them not to bring prosecution. Difficult to do, but possible. And I think that's, there's also another side thing that I've seen a couple times, although it's not very common. With respect to a responsible person who is determined to be responsible, or is responsible and supposed to be withholding and paying over. If they know that the taxes aren't being paid over, and they happen to be an employee, which many of them are. So many people work for the corporation, so they're also the owner, i.e. the responsible person potentially for the employment taxes on the employer side, but they're also an employee. They're getting paid as an employee, and they're getting their paycheck with withholding on it, and they get their W-2 at the end of the year that shows withholding. If that same person knows that the payroll taxes, the withholding taxes weren't paid over to the IRS, that person should not be claiming the withholding credit on their 1040 tax return. The IRS, they don't do it often, but we've seen cases where the IRS, in addition to charging 7202, they may charge something else on the 1040 for the responsible person who happened to be an employee who also claims withholding credit, knowing that the money was never sent to the IRS. And that's kind of an interesting spin. We've seen it a few times. We've also tried to see the DOJ try to do a sentencing enhancement for the person because they're in an abusive position of trust. They haven't been very successful on that because the position of trust, the victim here arguably with employment taxes is not the employee, it's the IRS. And the courts have not agreed that the employer is in a position of trust to the IRS, even though there's arguably a fiduciary duty and things like that. So the IRS, sometimes DOJ tries to get a 2-point sentencing enhancement. I don't believe they've been very successful in that. And just a final note with sentencing, for those of you that don't know, sentencing in tax cases is based on the tax loss. So it's very important to figure out what the tax loss is, try to minimize that. The government can bring in related conduct, so that for sentencing, they can bring in tax loss outside of the statute years. And so there's always things to advocate for your client when it comes to sentencing, because oftentimes when there's a criminal tax case and there's an indictment, there's been so many levels of review it's very difficult to win those cases, although possible. But the IRS and the DOJ will tout a 90-something% prosecution, successful prosecution in tax cases. And that's true. It's because there are in tax cases so many levels of review. And once it gets to the indictment, they usually have a good case. And the job is to reduce sentencing, reduce the tax loss. I think I covered what I would like to cover. Anything else, Michelle?
Can't think of anything at the moment. Okay, so the next thing that we were going to, so the take-home lesson in this whole thing is just always counsel clients, and for yourselves also, always play your withholding portion of your employment tax, because that is the one place that you can really run into a lot of problems. So there's also this alternative, Gary, you're going to talk about IRS civil injunctions.
Yes. So, you know, the IRS has the ability to do a civil injunction. An injunction is a court order that requires a party to refrain from some certain actions. They're generally done, they are done in district court, and it's under Code Section 7402A, which gives the IRS authority to do that. And so suits for injunction may be appropriate against employers and their responsible officers who have a history of pyramiding federal trust fund taxes and who continue to do that. And so rather than going criminal, the IRS through the DOJ can bring a civil injunction in district court. And often I've had revenue officers threaten that, and it doesn't scare me. It's not, to me, it's not something that I would much rather have that than criminal. And so the IRS and DOJ were doing the civil injunctions, and then they moved to more criminal. And I haven't seen, I think with COVID, I haven't done a lot of these. I think I've only seen one in 2021 so far come through, or maybe I haven't seen, maybe I've missed it. So I don't think they were doing a lot of them, but it is something that sometimes in criminal cases, we try to get the criminal people to back off and say that, why don't we do a civil injunction? And what does that do? It's a lot easier for the IRS. The IRS doesn't have to prove, guilt beyond a reasonable doubt in the criminal statute. Instead, they can go into district court and they can say, all they have to show is that this employer is not paying over in taxes and it's harming the government. Very easy to do. And what it does is then the government will ask the court to issue an order, and the order will basically order in a civil context the employer to follow the tax laws, to pay over, to withhold, to file timely. Also some things like to notify the IRS revenue officer of any new businesses that they open, any businesses that they close, any place they change their work. And it generally, it's kind of a monitoring system for about 5 years generally. It also requires generally the employer to send the tax returns to a revenue officer every quarter. It also requires generally for the employer to send over every month to the revenue officer proof of federal tax deposits. And so it has a myriad of requirements in a civil context that the employer is supposed to do. And so that's kind of, all right, come on in and do this. And what's the hammer then? The hammer is, well, now there's a court order. And now if you violate that court order, you're in contempt of a court order. And then it's easy for the IRS to come in and say, you're in contempt of a court order, and either ask civil or criminal intent. Criminal intent is the judge can, give you a warning, but can throw you in prison. They can, under civil, they can force you to pay fines, penalties. They can ask you to force you to shut your business down. It's just a much easier, it's much less resources for the IRS to do if they feel like there is an employer that's pyramiding and they want them to stop, and they're concerned they're not going to stop, and they want to have the hammer of the court order.
Gary, can you just explain what pyramiding is?
Pyramiding is just continually not paying employment taxes, taking the current payroll taxes, maybe paying some of the old year, but kind of continuing it so that it turns into a pyramid, right? I mean, I don't know the best way to describe it.
Yeah, just escalating or
just escalate. It just keeps going. It builds on itself and it keeps going. And so, you also may have to inform the revenue officer if you're transferring assets, dissipating assets. So it's a mechanism. We don't see it. We didn't see it for a while. We saw a lot of it. Then it seemed like the IRS was transitioning to criminal. And so I still think this remedy to the IRS is available. I much prefer it over anything else. Criminal, obviously. The only, I guess, negative side, there's a public record of it. And you know, so other than having a public record because it's in district court, if somebody searches it, it just really requires the taxpayer to remain current, which is what they should be doing anyways. And we advise people, companies, clients, if they can't stay current, they got to shut it down. You know, sometimes we have to give them tough love. Just shut it down. They kept it, you know, people, we all know with small businesses, it's their baby. They want to keep it open. And many of our clients and many small businesses, frankly, keep it open too long with the hopes that it's going to turn around. But clearly, if you can't pay employment taxes, same as sales tax. I know we're not talking about sales tax, but same thing. If you can't pay sales tax, you got to shut your business down. And so, again, civil injunctions are a tool in the IRS's tool belt, and we'd much rather see that than any criminal investigation.
Yeah, and of course, from a public record, I'd rather have a public record of a civil injunction than a criminal violation, or
Yes.
yeah. Like,
Yes.
no comparison. All right, so I think we're going to just talk briefly. Let me just share the screen again. A second. About the, did I share it?
Yes, you got it.
Yeah. About the employment retention credit. So as you know, this is part of the COVID relief, and it's only for 2020 through 2021 anyway. It's over a period of 7 quarters, and some limited situations, 8 quarters. But, you know, there have been a lot of companies out there who prepare these credit calculations and make determinations about whether or not employers are eligible for the credit. And so there's a lot of questions about whether that determination was done correctly. There's a mathematical computation to figure it out. If an employer doesn't qualify from a calculation of the fact that their wages went down by a certain percentage, then they can try to prove that they were at least partially suspended due to COVID orders that were in effect. And it's somewhat of a involved process to make sure that an employer is eligible for the credit. But I think, Gary, you wanted to talk about it.
Yeah, I mean, I think, you know, we can have a whole topic on the employee retention credit. I know Michele, I think, has done one before. And so what's going on here? Well, we're talking about enforcement. You hear on we all hear on the radio, on the TV, you know, Mr. Credit, get your credit, because it's about it's potentially as much as a $26,000 per employee, and so it could add up. And so there's a lot of what the IRS thinks is unscrupulous marketers out there, or what we call tax mills, pushing this credit, and the IRS is onto it. I've heard and I've been told that they have trained 300 agents on the ERC, I think like 60 hours of training. It's still not enough, because there must be millions of these credit claimed. But the IRS is looking at them. They are very concerned about them. They're going to be out auditing them. One of the questions I was told that they're asking on these audits is there a contingency fee? And while contingency fees are potentially permissible, it's a tip off. What the IRS claims, it's a tip off to potentially something going wrong where the incentives are mismatched, meaning that the company that is providing the service may have an incentive to push this through so they can get their contingency fee.
I just want to, so what Gary said is, you know, taking a percentage of the credit as your payment, as opposed to just a standard hourly fee or even a flat fee. But if someone's taking a commission as a percentage of the credit, then they sort of have a stake in the venture of trying to maximize the credit. It takes away a little bit from the credibility of in the IRS's eyes.
I mean,
plenty of people do that setup, and it's completely fine, and they have that format, but it's just something to think about.
I mean, they did, you know, criminal investigations get involved. They did go after I think it was a Houston company who was offering the services, and they just were basically telling everybody that they qualified regardless. The qualifications are complicated. They changed from 2020 to 2021. It's not automatic. They make it everybody. The ads I hear make it sound like everybody's qualified for it. And the IRS will say if it's too good to be true, it probably is. Although some of it is too good to be true, and it's not, and it's right, okay? Because there is a lot of money here, and many people and many employers do qualify for it. We've advised clients on some of the technical aspects of this. We always feel better when we hear that the company that is doing the calculation is hourly or flat fee and not contingency. And so just know it's out there. There will be more audits of this. There will be criminal investigations. Part of the problem is that also some of these companies in their agreements, they provide audit defense, and that means they're going to handle the audit. Not always the best situation. And so be wary of that as well, in my opinion. But be aware. I think we're gonna see a lot of these audits happening soon.
Okay, and the next thing we want to, and we're just going to touch on this because this could be a whole webinar in and of itself, it's dealing with the California employment tax issues, and that is discussing how they've adopted a much stricter standard for determining whether or not a worker is an employee or not, and because of the gig economy and all that kind of stuff. So I don't know, Gary wanted to talk about that.
Yeah, so with respect to California, this is more about misclassification, right, and less about the trust fund portion of the tax. There's less trust fund, obviously, because there's no Social Security or Medicare at the California level. That being said, with respect to responsible person in California, as Michele touched on in the federal trust fund recovery penalty situation, the responsible person is responsible for all of the employment taxes if they're deemed to be a responsible person. We'll talk a little bit more about that. But what we've all heard about over the years is that AB5, right? Pretty much all workers are assumed to be employees unless the employer can affirmatively satisfy what they're calling the ABC test, right? And the ABC test A, that the worker is free from the control and direction, from their work, that the worker performs work that is outside the usual course of the hiring entity's business. That's the big catch. That's the big one here. And C, that the worker is customarily engaged in an independently established trade, occupation, or business. And there was a challenge to AB5, I believe, from the California Trucking Association, and the Ninth Circuit, I think, upheld AB5. There was an appeal to the Supreme Court, and the Supreme Court denied the certiorari, I think, this summer. So AB5 is here. And really what it means is that the EDD will come in and audit, and they'll say everybody's an employee unless you find the exception in AB5, and that the B part of the ABC is what really did it. And one way to think about it is if the business is, what the business does, the main service of the business, anybody who provides that service, they believe is an employee unless you can find an exception. And so the EDD will come about in their audits. And I think it's also important to talk about how an EDD audit happens. We see with respect to misclassification issues, we see the EDD normally auditing way less IRS audits. That's different than most every area of tax law. With respect to employment taxes and employee classification, I do EDD audits. I have probably 6 of them going on right now. I think I have 1 IRS employee classification audit going on. So we see it in the EDD. How do most all of the cases get picked up by the EDD? In my opinion, generally it's from an unemployment claim. And what happens in an unemployment claim is that a person, let's assume a person is an independent contractor with the employee. They've gotten 1099s, and they want to be an independent contractor. Let's assume the worker is not going to complain. They want to be an independent contractor. And maybe they were an independent contractor last year, and and maybe they left you and then left the employer, and then this year they work for somebody else. Maybe they're an employee or maybe they're not, but they lose work and they go claim unemployment for whatever reason, whether they're entitled to it or not. They don't know. They want unemployment. On the EDD form, the EDD has been very smart and coy about this. Is one of the questions is, where have you worked in the last 5 years? Not where have you been an employee? And many people, many individuals who are claiming unemployment aren't lawyers. They're not reading carefully. When it says where you work, they'll list every place that paid them, including the 1099 payees, the independent contractors, and maybe they were independent contractors. But they're not trying to get somebody in trouble. They'll just list every place they got paid in the last 5 years. The EDD will look at that and pick those for audit. And that's how I've seen most of these EDD audits occur. Okay. And with respect to the EDD audits, again, I can't tell you that the EDD, especially now, everybody's an employee, and you have to argue, they're not. And the obvious ones where they're not is the obvious ones we all know about: a plumber who has his own business, who comes out once or twice, those types of things. But it's always a battle. It could be. We can't get into too much because I can talk hours on this. I just kind of want to touch on what you should be looking for with respect to the EDD audits. Once a determination is made by the auditor, your right is then to go to the CUIB, California Unemployment Insurance Appeal Board. And that's typically the forum where people go to when they have an unemployment claim that is denied. It is staffed by administrative law judges, basically lawyers who are full-time. And in addition to hearing unemployment denial claims, they hear what they call tax cases, worker classification cases. And so you have to go before them. It's a hearing. The rules of evidence don't really apply. It just depends. They're not supposed to apply, but sometimes the ALJ will apply them. And it's also very difficult to win there, although you can win there. We've won there numerous times. And if you lose there, you got to go to Superior Court, which is also very expensive, or just cost. It's pretty much, it's cost prohibitive for many people. So usually the CUIB, the California Unemployment Insurance Appeal Board, is where you got to go. With respect to the collection side of this, as I said, the unpaid employment taxes, the responsible person is responsible for 100% of the tax, and they will go after those individuals. And the EDD is famous, as probably most of you know, as the FTB. Just they want to collect. We don't have as many tools in our tool belt as we do with the IRS. I've even had EDD collectors say, we don't do installment agreements, which is a lie, because they do installment agreements, and I've done installment agreements. But I've had more than one say, we don't do installment agreements. So they're notoriously difficult on the collection side. And so the takeaway is let's get those employment taxes paid to California as well. And I think those are the major topics. Michelle, if you have anything to add on.
Just a little bit more. So here's where a problem can come up: is you have a disgruntled employee or someone, or like Gary mentioned, unemployment claim that goes to the EDD, and that could trigger a whole process over to the IRS, because these agencies communicate with each other. And so what can start as something simple on the EDD side can then go to the IRS and all these other cascading problems that we were talking about. And I would say with the EDD, the audits we see always tend to be worker classification. We're not really looking at collection cases. The IRS, it's not as much worker classification as it is looking at who's responsible for paying. And I'm just going to quickly mention one thing. So the IRS has this voluntary classification settlement program, and I have a couple of slides here on it. We're almost at the end of the hour. I'm not going to get too detailed, but you fill out this IRS form 8952, which is an application for a voluntary classification settlement program. So you can reclassify, you can voluntarily come forward and reclassify workers as employees. And the penalties are minimal. Like many of these other voluntary programs, they just want to get you into the system, and they're encouraging you to do that. And the reason you might want to do this is if you're busy with an EDD audit and you think it's not going well, you need to get in front of it, because you can no longer do the voluntary program once the IRS has notified you. So you want to, if you see that this is what's happening, and you might get stuck in this situation with all these workers being reclassified, then a place to go is to this program. And I have a slide in here about who's eligible. So one of the issues is that you had to have been, so if you were considering these other workers to be independent contractors, you need to be tax compliant with them, which means you needed to have at least filed 1099s. And you know, and also the taxpayer can't be under audit by the Department of Labor. So the Department of Labor also does these worker classification type of cases on the federal level, but if they're under audit with the EDD, it doesn't stop you from being eligible for the voluntary reclassification program. And so that's just one of the ways that you can try to nip this in the bud, or realize that, you know, it's going to come on down. So get in front of it and minimize your penalties. We only had a couple questions. Okay, so Sally asks, are executives at payroll companies ever responsible parties? So that would only come up if somehow it can be shown that the executive at the payroll company is actually a decision maker. Probably not, but once again, it depends. You have to see the fact situation. But if the taxpayer is giving all this information to the payroll company and making all the decisions about who can pay what, Gary, you can chime in.
Yeah,
and the payroll company is just processing it.
I think it depends. I think it depends on the situation. So if a payroll company has been given the money, right? The extreme case, and I've seen this. The payroll company embezzles the money, takes the money, and doesn't pay it over, uses it for another purpose. That is,
well, that's on a whole different level, yeah.
Thing, right? And so if the executive payroll company doesn't have the ability to pay, meaning doesn't have signature authority of the bank account and just can't pay, then they can't be determined to be willful. But if they have the ability to pay, meaning they were supposed to pay it over and they use the money for another source, then they could be, I think they're in bigger trouble than just being responsible. But we have had cases, and just know this, I've had cases where payroll companies have taken the money and embezzled it. The IRS will potentially go after the responsible person, which could be the executive. But that, remember, TFRP is kind of like joint and several liability. It's a collection tool. They can collect from the company and from the responsible person. So I've had situations where the IRS will say, we're sorry for your client. Your client needs to file a civil suit against the payroll. But guess what? Your client still needs to pay the employment taxes over to us, i.e. like double paying it, because they paid it to the payroll company that took it. But the IRS position is that the employer, the company, is still responsible for the unpaid taxes. We can get them out of the penalties, but we've had that situation. So it just depends on the facts, I guess, is the answer to that question.
Yeah, I think so. And then the other question, is it willful when there is a finding of misclassification of employees as independent contractors? Again, you need a lot more facts to figure that one out.
Generally for criminal willfulness, very unusual.
Well, I don't know if it's because we weren't, for criminal, we weren't talking about worker classification. We were talking about paying withholding. So I guess in that situation, you weren't paying the withholding.
This classification, there is potential, you know, if you intentionally misclassify and they can prove, then there's a potential criminal, you know, issue here. Meaning if the IRS and the DOJ has you on an email or wiretap or something that says, hey, let's pay these people, we know they're employees, let's pay them as independent contractors, we don't have to pay over the employment taxes. Sure, that could be a criminal case. I've never seen that happen like that, but potentially that could be a criminal case.
But that's not what 7202 contemplates, though. 7202 would be related to then you were willfully failing to pay over the trust fund portion.
To say, but they can argue that yeah, I mean,
Yeah, it depends. It's not quite, all right. Well, anyway, I don't see any other questions. I want to thank everybody for coming today. Next month, we will have a program on tax issues and international divorces. If you would like to get more involved in the tax section, please come to our next monthly meeting, which will be on the third Thursday of November at 8:30 in the morning on Zoom. I believe that is November 17th. And have a wonderful rest of your day. Bye.